My name is Andrea Johnson. I'm Senior Counsel for State Policy at the National Women's Law Center, which is located in DC, but I get to work with great legislatures like yours across the country. We've been working for over 45 years to remove barriers to women's equal treatment in the workplace, and particularly those that suppress women's wages. I really appreciate this opportunity to testify today because closing the wage gap here is an urgent matter for all the reasons that Georgia laid out. Now, the Federal Equal Pay Act and Rhode Island's current equal pay law have been on the books for many decades, but loopholes and inadequacies have arisen in those laws that have allowed pay discrimination to persist. This bill is so great because it addresses those inadequacies on many fronts and would actually have some proactive measures like the salary history measure, like the pay transparency measures that would work to reduce litigation by creating a space in which that pay gaps aren't perpetuated from the front end right at employment, and creating a space for employees to feel comfortable discussing their wages and addressing any issues that arise. So I've been working with state legislators across the country on these exact types of protections. Dozens of states have enacted these types of protections in just the last few years. And the language in this bill is the same in many circumstances as those bills that have passed recently. Talking about the factor other than sex or race needing to be job related, consistent with business necessity, accounting for the entire differential. That's language that is in other bills. It is not unknown or revolutionary language. And all of this is really essential to closing the wage gap. And I'd like to just touch on a few pieces. Comparable work has come up several times. It's incredibly important that this bill moves from the current equal work standard in the current Rhode Island law, equal pay law, to the comparable work standard, because the equal work standard is a rigid standard that many courts have narrowly interpreted to mean identical work. So cases have been thrown out if the plaintiff can't show that her male counterpart has the same job title, exactly the same responsibilities, and the same working conditions. Those plaintiffs aren't even getting their full day in court because the case is being thrown out right at the front end. And that equal work standard was put into the Federal Equal Pay Act over 50 years ago, and it contemplated a different world where women were working in standardized factory jobs, producing the same widgets as men, but being paid under a woman's pay scale, and the men were being paid under the men's pay scale, but they were doing the exact same jobs. That's the kind of scenario that the Equal Pay Act then was trying to get at. That standard doesn't reflect the reality of today's workplaces and jobs where women are more and more in professional jobs that do not have that same sort of standardized, there might be minute differences that aren't truly relevant to the fact that, to comparing the jobs, but the general responsibilities are similar, and the skills required and the effort required. So this standard right now is denying too many pay discrimination victims the opportunity to have their claims fully heard. And so switching to comparable work makes sure that we will have them fully heard. It'll ensure that pay discrimination cases aren't thrown out based on minor differences in the work being compared. And comparable work is not an unknown term. It's used in about, I think, 10 other states' equal pay laws, including in Massachusetts and Oregon, where it has been the standard for several decades. And Massachusetts recently clarified in their law that comparable work standard, that's a standard that's meant to be broader than the equal work standard. And they've issued very recently helpful guidance about the standard, making clear, much as the Rhode Island bill already does in the language of the bill, that the jobs being compared must be viewed as a composite of the skill, effort, responsibility, and working conditions required. Oregon, New Jersey, and California have also been moving in recent years away from the equal work standard towards a broader and fairer standard. So this is something that is part of the more common lexicon for employers, and Massachusetts has some helpful guidance to look to. Touching on remedies, as Georgia said, weak remedies for pay discrimination, for example, only requiring that an employer pay little more than what they should have paid an employee to begin with, which is basically the situation right now under current Rhode Island equal pay law. That kind of weak remedy would mean that the employers that discriminate in pay can come out ahead by gambling that they won't get caught. Moreover, an employee who is a victim of pay discrimination can suffer significant financial losses and emotional harm, making her less likely to be able to take care of herself and her family, and undermining her retirement security. So it's really important that the damages provided for in an equal pay law, that they ensure that victims of pay discrimination are made whole for the discrimination they experience, and that they're also sufficiently high to ensure that it doesn't pay to discriminate. And employers are incentivized to comply with the law. And we think that those damages are really the incentive that we need to make sure employers are doing these evaluations of their pay practice, of the practices and not just hiding their head in the sand, because that's not a defense to an equal pay claim. You should be looking at your books already. Similar damages have been included in equal pay laws in neighboring states like New Jersey, New York, Vermont, and Connecticut. And likewise, the civil penalty amounts are similar to those provided in Illinois, Vermont, New Hampshire, and Delaware, just to name a few states. And I'll end by just saying that this self-evaluation defense, or what it's been called a safe harbor that's been brought up in Massachusetts, is something that we strongly oppose the inclusion of, especially as an affirmative defense to liability or a defense to damages. It seems fundamentally unacceptable that an individual who is in fact a victim of pay discrimination and who has in fact suffered harm would then be denied a remedy for that injury, even though the self-evaluation completed by the employer failed to avoid this harm. So as George was explaining, the self-evaluation defense Massachusetts has is if you, within the last 3 years, did a self-evaluation and made reasonable progress towards closing the wage gaps, you then have a complete defense to liability. But that's even if you found that this person's been discriminated against. So that creates a sort of fundamentally unfair situation. You found that somebody's been discriminated against, but since you did a self-evaluation, and you made some reasonable progress, again, an undefined, vague term, that would get you off scot-free. We are very concerned that that would create a significant loophole in Rhode Island's equal pay law, undermining your existing protections. And I'll just flag that a number of companies have been announcing in recent years that they've done self-evaluations of their pay practices and announced that they have no wage gap. You might have heard about these companies in the news, but they often don't show their math and what are the things that they're looking at to determine whether their evaluations are consistent with their obligations under equal pay laws. And one notable situation was Google announced that they had no pay gap, and then shortly thereafter, the U.S. Department of Labor alleged that they had, in fact, labor practices that included systemic compensation disparities against women pretty much across the entire workforce. So that announcement came out just a few days after they announced they had done a self-evaluation. So we have concerns that unidentified, no parameters around a self-evaluation could create a large loophole given those practices. And I'll just end by saying only Massachusetts has an equal pay self-evaluation as an affirmative defense to liability. Other states have considered self-evaluation as an affirmative defense to their equal pay laws, but have rejected it. And moreover, the good faith of an employer, the fact that they're doing pay evaluations, that is something that can come into account, be taken into account in the court or the department imposing punitive damages or civil penalties. That their good faith is a factor that will be taken into account in the law. And one other thing, a mention was made of carving out small employers. That is a very disturbing precedent to set under Federal Equal Pay Act. There is no carve out for small employers. I think very few states have that, and we need all employees to be paid fairly. And so that is a precedent that would be a bad one for Rhode Island to set. So through a lot, I'm happy to take questions, but thank you for working on this.